Every week we are joined by attorney Phil Harding. So Phil, what are we talking about today? I know it has something to do with the jury.
It does, and let's just kind of run through a little role play here.
Okay.
You know, most people, they get the jury summons and they go, yes, I finally got the gold. They don't say that.
No, I was nervous when I got mine. I was like, oh no, I don't want to do this.
I know.
But you have to.
Yeah. Look, we're one of the handful of countries that actually let our peers decide who's right and who's wrong, and not, you know, some governmental officials. So I want to talk about juries. I want to talk about what they never know about. And if we have time, I'm going to go into this one trial that I had that the jury hated me. They started off loving me, but I was preventing a mistrial. First of all, let's talk about what jurors never know about.
Okay.
And the first thing is that the parties have tried to settle, right? And that's Rule 408. So before you go to trial, the judge says you have to go to a thing called mediation in front of a retired judge. And then if you don't settle at that, I'll give you a trial date, right? But you can never mention what's said at the mediation, how much is offered, counteroffer, anything. Also, if there's insurance, right? Car accident or whatever, there is probably car insurance, but if you mention it under Rule 411, it could be a mistrial.
There's a lot to it.
Yeah, and that's what happened to me. And next, the judges excluded stuff. And then finally, if the defense gets up at the beginning and they say, hey, ladies and gentlemen of the jury, we've accepted liability, so now it's all about the money. Well, yeah, it's about the money, because you can say, I'm sorry, but like if you broke your neighbor's window, you'd go over and pay for it.
Right.
Same thing, right? So that's what's going on. And let's talk about it. Once the jury, or once the defense says, hey, we've accepted liability, it is no longer relevant. Let's talk about a car accident.
Okay.
Let's say the guy was drunk. That ran into you. That will never come in.
Why?
I know, it doesn't that.
Why can't we know like how the accident took place, where it took place, what he was doing? Why?
Well, you'll know where it took place, but not what happened before. Because when the defense says, we've accepted liability, it's called a 402, 403 objection. And what it means is, once they've accepted liability, it's no longer relevant how the accident took place, right? But only how much someone was injured. So that's why defense always gets up and says, we've accepted liability, like they're great people. No, they're not. They're hiding stuff. And let me tell you why it's excluded. So if you are on a jury, there will be a bunch of jury instructions. And perhaps we have one here. The jury instructions itself,
right here.
One of them says, hey, any finding of fact you must be based on probabilities, not possibilities. Look down here. You must not be influenced by sympathy, bias, or prejudice for or against a party. So let's say there's a car accident.
Yeah.
They've accepted liability and the guy was drunk. Wouldn't you want to just like nail the drunk?
Well, he was drunk. Yeah, it was his fault, right?
It was his fault. But if you found out that he was drunk, you may give more money than just how much someone is injured. Look, I disagree with it as well. But you get like 30 or so jury instructions. And you know what? Let's talk a little bit about this case so I had this bike-on-bike accident, right? The guy in the front was a criminal defense attorney, and he went out into my client's lane, zipped back in, and his buddy behind him ran into my guy. So then the first thing that he said to his buddy was like, hey, just give it to your insurance and let them run with it, okay? So that was the first thing that he said. Now we go to trial. And he's a criminal defense attorney, so I go up to him and say, look, you're a criminal defense, you're not a civil attorney. I know you told your buddy, just turn it over to the insurance company. Please don't mention insurance, because if you do, it'll be a mistrial. And he's like, cool, gotcha. So then he gets up, he's testifying, he's like, well, that's my testimony, except for what Mr. Harding said I can't talk about. And the jurors were like, what? And jurors get to write down questions. So everyone's shot it up to the judge. Before that, the jury was loving me. And they're like, what did Mr. Harding say? What did Mr. Harding say?
So, yes, he put something in their mind. So that's why it was a mistrial, right?
Well, no, it wasn't a mistrial. So I went up to the judge and I said, Judge, you have to give an instruction to the jury that says there are some things that are excluded. And the judge says, nope, not going to do anything. So we went through with trial. We won. But normally jurors come out and talk to me. They kept their head down and they bolted. They thought I was hiding stuff.
That's why you need to reach out to this guy. He won at the end of everything. If you'd like to reach Harding and Associates directly, call 303-762-9500. That's 303-762-9500. You can get a free consultation anytime, and you can find Phil online at hlaw.com. That's hlaw.com. Thanks again, Phil, for sponsoring the segment.
Thank you.